It is March 20th. We are in Senate Judiciary. We have Mark Paul from the Defense General's office here to speak with us about each.
Thank you. And so my testimony is going to be fairly brief. We are what I would call reluctant supporters of H2. We would like to see H2 pass in the form that it's written. And there's a few particular reasons for that, and I'll get to the part where we're a little reluctant in a minute. But that doesn't mean we don't support it. So H2 basically does two things. One is that it raises the age of juvenile jurisdiction from age 10 to age 12. We think that that is a very positive change. It's a very small change. There's very few 10 and 11-year-olds who've been charged, but it's a significant change because in my experience as a practitioner, 10 and 11-year-olds, I have represented several 10 and 11-year-olds. I have never, ever had a 10 or 11-year-old be found competent, which means that in every case where we charge 10 and 11-year-olds and they are not found competent, in the vast majority of cases, we're spending a lot of time and a lot of money and creating a lot of intervention in a way that's not necessarily helpful because it leads nowhere. It costs a lot of money to find somebody not competent. That usually means multiple extra witnesses and a lot of court time and attorney time and witness time, which can be very expensive. And at the end of the day, 10 and 11-year-olds, just not for any other reason but their developmental immaturity, are generally by psychologists found, not just generally, in every case that I'm aware of, found by psychologists to be not capable of making the decisions that you need to make in order to be in court. And that's not actually the end of the world because we have a whole system for that, which is when we have a situation where a child is committing offenses that are serious and dangerous and should be addressed by the court system, but they're too young to actually make the decisions you need to make to face criminal or delinquency liability for that. In those cases, generally what we're looking at is essentially not a problem with a particular child, because when you're 10 or 11 and you're making offenses, that's probably not a you problem, that's probably a family problem. And we have a child welfare system that deals with those cases. And so for the 10 and 11-year-olds, what I would say is this, is first of all, it does not make sense to have them in the delinquency system at all. In practice, they just simply are not in the delinquency system because they have found to be incompetent. And so they get charged. We go through competency evaluations, we go through competency hearings, but it's 10 or 11, even the brightest kids are just not developmentally at an age where they can participate in the court system in an effective way. And so they get found incompetent because they wind up in the child welfare system where competence is not required. And it's more addressing problems within a family than within an individual. And that's usually the right approach for young people that age. So we are very supportive of change from age 10 to age 12. But like we say, that affects a small but important group of children. And it puts us in line with the rest of the country. We have been really lagging behind the rest of the country in our lower age of jurisdiction. I was actually at a conference once that was very embarrassing for me because they asked us, it was a conference of people who practice juvenile appellate law, which I do, and they were asking us all what the lowest age of jurisdiction in your state was. And when I said 10, people were shocked and outraged, including people from states that I did not want to be sort of negatively compared to. So from that perspective, we think that this is really important change. The next,
do you have numbers? How many people are we talking about?
I don't have numbers, but I can tell you that in my entire career, I went through and counted this. So when I testified in the House, I said that I had represented 6 people who were 10 or 11. I went back to my records and actually corrected that, found 3 more from when I was in private practice that I wasn't counting. So I represented 9 in my whole 17-year career. So it is not very common, and it is growing less common. When I look back at those first 3 I had, that I found after I testified, were from my first year of practice. And I never had another year of practice where I had through cases of 10 or 11 years. So that was, 2010 or not, 2009. That would have been,
So we're talking about 9 people in 17 years.
for my actual practices. So it's not because it happened, but it's a very uncommon, and there is a whole other avenue to deal with it. It's usually more appropriate because honestly, when you're talking about children who are 10 or 11 years old and are committing offenses, you really do generally not have a problem that can be treated by just treating the child alone. You really need to be looking at the family because when you have a 10 or 11-year-old, that's usually a sign of a lack of supervision or something else going on in the family, not necessarily something that can be treated just by addressing the child. The next section I think is also important, and that is raising the age of supervision. So we always talk about the age of jurisdiction as if it's one thing, and it's not. It's actually, we have so many different ages of jurisdiction in Vermont that I don't think I could give you a list of them. We have different ages of jurisdiction for 3 different categories of offense type and 6 different categories of age, and they intermingle on a matrix. So like when I make a chart, you basically have a 6x3 chart showing where young people are in the, at very low risk and low age end are always in the juvenile justice system and can't be transferred to the criminal justice system. And then at the very high age, high risk end are always in the criminal justice system and never in the juvenile justice system. And then as age and risk reduce, there's always they can start in one place and transfer to another. So we actually have a real matrix of ages of jurisdiction. One of the ages of jurisdiction that we don't talk about much in Vermont is the upper age of jurisdiction, the age at which TCF stops supervising something. So we always talk about Vermont like we're an outlier because we have what I call a point of entry age of 19, which is larger than anybody, the other states are at 18. So we have a point of entry age with 1 year higher than states in the rest of the country. But our actual upper age of jurisdiction is lower than states. So right now, our upper age of jurisdiction is 19 and a half for people who committed offenses when they were 16 or 17 years old, and it's 20 and a half for people who committed offenses when they're 18 years old. That means that somebody who's 18 years old and commits an offense can be supervised. Let's say they're 18 years old and about to turn 19. So they can only be supervised by DCF for about 6 months. That's actually makes us a real outlier in terms of having a much lower age of juvenile jurisdiction than most states in the country. Almost every other state in the country has ages that go at least age 21 or 21 and a half. Other states, including Washington State, have gone as high as age 25. We're nowhere near there. So when we talk about juvenile jurisdiction and we talk about Vermont like we're an outlier on one small point. We are still very much not ahead of the curve when it comes to the upper age of jurisdiction and the lower age of jurisdiction. And this bill starts to address both of those by raising the lower age of jurisdiction and by raising the upper age of jurisdiction for supervision purposes, not the point of entry, but from supervision from 19 and a half to 20 and a half and from 20 and a half to 21 and a half for the 18-year-olds. And we're very supportive of that. We think that that's actually important in terms of making this successful, because there are times when we have young people who even with a misdemeanor, even with something that's not really transferable, doesn't belong in adult court, but we need more time in the juvenile court for treatment, particularly because like I said, a lot of these cases, especially with young people, especially with people who are still living with their parents, which is something that's much more common now. When I started practicing, we just had a recent census update. And one of the questions the census asks, is they look at 26-year-olds in particular, and they say, where do 26-year-olds live? And when I started practicing, there was about an even split of 26-year-olds. There was no majority. There was sort of pluralities, and there was an even split between 26-year-olds living with roommates or living with a partner or significant other. They were the top two categories. Below that were living alone, married, and living with a spouse, or living with your parents. Today, the highest category for 26-year-olds is living with your parents. That has changed. It's actually started to drop again. It went up 50% during the pandemic. 50% of 26-year-olds were living with their parents during the pandemic. That started to drop off, but it's nowhere near the number that it used to be at. And we see that with other things too. So the age of 18 as a point of entry into the juvenile justice system was set in 1899 when the first juvenile court was opened in Chicago. And that was not based on brain science. They didn't have MRIs back then. They didn't have any kind of brain science. It was based on social status. And so it was based on the idea that at age 18, that is the point at which people were getting married, having children, and entering a career where they were no longer just a medial worker, but were probably entering a lifetime career. And those are all markers that we have seen change dramatically, especially over the last 10 or 15 years, those social markers. People are getting married much later than they were getting married before. They're moving out of their parents' house much later than they were moving out of their parents' house before. They are starting careers much later than they started before. They're entering the workforce later than they started before. When I was in high schooler, every high school kid had a job. It was just sort of standard. And it was easy too. Any high school kid could walk into McDonald's and get hired. Today, I work with my clients, and one of the first things I try to do with young people who have found themselves in legal trouble is I try to get them a job. I think that's an incredibly stabilizing force, and it really exposes young people to people who are older and more stable, and then a lot of times that's the exposure they need. It's not going to be impossible. McDonald's is being staffed in large part by 30 and 40-year-olds. It's not being staffed by 16-year-olds anymore. And that's true all over the place. Trying to get young people into lifeguarding jobs and stuff is tough because you have 40-year-old lifeguarding. This whole class of jobs, and when I was a kid, were reserved for teenagers, has disappeared, and they've become jobs that are adult jobs. And so it's a lot less employment available for teenagers who want to. And then you add to that just all of the things that we've done that have just changed how we as the state treat teenagers. So when I was a young person, of course, teenagers that started smoking cigarettes at age 18, and in fact, you can get carded, really carded you after, so you can buy cigarettes at pretty much any age. Now we've reached the age of smoking to age 21, and I watch people getting carded who have bald hair like me. We raised the age of drinking from 18 to 21. We have, in all different ways, we have been tinkering with that. And there's a lot of talk about raising the age at which young people can make the decision to drop out of school on their own. We are, in a lot of ways, as a government, we are adapting to the changes that we are seeing in youth in terms of the fact that they're maturing later and later than they used to. And so because of that, we think that the changes that are incorporated into this bill really appropriately address changes that are happening in society. And because of that, we are supportive of all of the changes that I have talked about so far. And that gets us to the second to last section of the bill, which is a series of sections which address shifting the next phase of implementation of Raise the Age from April 1st of this year to 2027. And we support that, and that's where we get to the part where I say we support it reluctantly. We support it reluctantly because we're really excited for this to happen. 18-year-olds have been incorporated into the juvenile justice system now for many, many years. I think DCF showed a chart of caseloads. I think it was a little deceptive because it started in 2020, which is not actually when we started. including the 18-year-olds in the system. And it also represented a point at which during the pandemic, we had the lowest number of filings we had ever had in both the criminal and the juvenile justice system. It was, and that was a nationwide statistic. Actually, the reason I'm testifying today and not the past couple of days is I spent the past couple of days at the National Conference of Juvenile and Family Court Judges in Boston, and they were very focused, the judges were very focused on the effects of the pandemic on their caseloads. And they had national statistics showing that all across the country, the number of filings for delinquency for criminal petitions just plummeted in 2020. And so to have a chart that shows 2020 and everything starts growing in 2020 is a little deceptive because that was the pandemic. So everything shrunk in 2020 and then grew as we came out of the pandemic. And so what I would say is this, is that we're very supportive of raising the age here. We really want to see 19-year-olds in the system. We think it makes sense. 19-year-olds are already treated as juveniles in Vermont when they are charged as 16 or 17 years old. They're still in the juvenile system till age 19. So it's not as if DCF does not have experience working with 19-year-olds. In fact, they work with people at age 20 and a half right now, and they've been supportive of the change to age 21 and a half. So they're not unfamiliar with this population. They've got the people and the skills they need to work with that population. What they don't have, I believe, is the resources to work with that population. And that's the reason why we say that we reluctantly support this delay of the next phase of implementation of Raise the Age. And the reason is because it is not a system that's resourced for 19-year-olds right now. And we think that what this law is actually a really good law. And we don't actually think that we need to defend that very hard, because when you look at it, the inclusion of 18-year-olds in the system has been incredibly successful. There's no reason to believe that including 19-year-olds will not also be incredibly successful. As someone who has a 17-year-old and a 20-year-old right now, I can tell you there's almost no difference between 18 and 19-year-olds. Like I've seen that happen, and I've got kids on both sides of the gap right now.
Yeah. So I have a couple, because this is a pretty stark departure from the testimony last year when we were talking about expansion, and I would argue DCF has more resources now than they did then. So I'm a little confused. And based on what you just said, with 18 and 19-year-olds not being significantly different, if they're resourced for 18-year-olds, why wouldn't they be resourced for 19-year-olds?
Because they have contracts with providers that allow them to serve 18-year-olds, but not 19-year-olds.
That seems like a simple contract change.
It seemed like a simple contract change, and it seems to not be as simple as it seems. This is where I say that we are disappointed. We're disappointed that the changes haven't been made. We're disappointed that the programs aren't in place, but they are in place. And if April 1st came around and DCF was told you have to start accommodating 19-year-olds, I think we would find ourselves in a situation where there would be, we don't want anybody put into a situation of failure. My main concern is for my clients, and I don't want to have a 19-year-old client who is put into a situation where there are no resources available for them and they fail because of that. To me, that is, I mean, that's why I say I am disappointed in the fact that we are not ready to raise the age. I wish we were, but I do not want to be putting my clients into a system that is not prepared for them. And
If we keep postponing, though, we've seen year after year, DCF come in and say, oh, we just need to postpone. What is to force them to ever get the resources or get ready? If they know they can just come here every year and postpone it.
And I think at a policy level, there is change happening, and it's happening slowly, and it's happening with, 2 steps forward, 1 step back. One of the things I'm most disappointed about, I sit on the committee that oversees the planning for the proposed new juvenile facility in Virgins. The first meetings that we had, there was already architectural drawings prepared. There's already a programmatic scheme in place, and they had a provision. They had 3 different buildings, one of which was specifically to house 18 and 19-year-olds. And there's some really good reason for that having to do with federal laws about sight and sound separation between people over the age of 18 and under the age of 18. And so we looked at that and saw that that was a really positive step that TCF was planning for the 18 and 19-year-olds in that program. 2 meetings later, there's new architectural drawings, and they have eliminated the 18 and 19-year-old program from the Virginia's facility. There was not a really clear explanation as to why that was. There still, from my perspective, has not been a clear explanation as to why that was. But that's what I'm talking about. And I'm saying there is not resources. If on April 1st we were to have 19-year-olds in the system, we would be in a situation where you could have a 19-year-old who was in a state of crisis, who really needed stabilization and needed a facility like Red Clover or like the proposed facility, something with some real security and really highly trained staff. And we would not have that facility available. And that would, in my opinion, be not just a tragedy for the system, but a tragedy for that client of mine. And that is what I do not want to see happen. And so I am not happy that we are in a situation where we are not ready to take in 19-year-olds. But that's the situation we're in. And I don't want to see us setting young people up for failure. And I think that's what we can do.
But that decision by DCF is almost proof to my point that without any line in the sand that they have to be ready, they'll just make decisions to not be ready.
And I can't speak to DCF's decision making. I can simply say that I'm not looking at it as is this a fair outcome or is this the right outcome? I'm looking at this as what's going to be best for my 19-year-olds. Right now, I have a 19-year-old, and if they go into the criminal court system, it's not great, but there are things I can do that I can use that work with, that I can use deferred sentencing schemes, and I can use youthful offender petitions to, even though they're in the adult system, try to give them some of the benefits of the juvenile justice system. If they're in a juvenile justice system that can't accommodate them, then we're going to end up with headlines. And headlines and children who are harmed. When children are placed in placements that are not designed for them, they come to harm. It's been studied all over the country. That happens to people who are placed in places that are not appropriate for them clinically and not appropriate for them age-wise. They come to harm in those places. And if we don't have those places that are appropriate for that age, we're going to be putting kids in places that don't be right. And strangely enough, as much as both I will say that I don't want young people in DOC custody, and DOC has said that they do not want young people in their custody. When they have to have somebody in their custody, they have the systems in place to at least keep that person safe. Everybody will agree it's not an ideal situation, but they can keep that person safe. And I don't believe at this point that DCF has those systems. DCF, when they have to deal with someone who is 19-year-olds in crisis, ends up doing things like staffing them in a hotel room with DCF caseworker, which is not only incredibly dangerous for the DCF caseworker, as you've probably heard from the union at times, it's incredibly dangerous for the youth. That is not the clinical environment that a youth in crisis should be in. It's in the opposite of the clinical environment that a youth in crisis should be in. And we end up in really bad situations in those cases, and we don't want to see that happen. So I'm not happy to be seen here saying that we support delaying raise the age. But I don't see any other choice from the perspective of my clients.
You're familiar with the Columbia study that showed that young people who go through the adult system rather than the juvenile system are 34 times more likely to have escalating criminology and negative impacts on their life course. Yes. That's a better outcome.
It is a better outcome than some of the things that happen in some of the facilities that people have placed in adult group. I hate to say that, but we have had, all you have to do is go back to the 7 Days article, Saving Grace, which was a real sort of expert thing that happened at Woodside. And from my perspective, because some of those are hard to talk about without tearing up, some of those are my clients, and those are people I care deeply about. And from my perspective, yes, I understand the harm and danger and risk and the problems that go along with putting youth into adult facilities. And yet, do I think the average juvenile facility that is in a place to take the youth that Woodside was taking and do a better job than Woodside did? No, I don't think we're there.
And DCF is actively making decisions to prevent us from getting there.
I don't know about DCF's decision-making process. All I can say is that I'm on that committee, and at first there was a plan for 18 and 19-year-olds, and then there wasn't, and I have not gotten a clear answer as to why that changed. I've gotten when I've asked, it's not as if I haven't asked, I asked in the way that I do, which can be kind of annoying, until I get an answer. And I've been told that, they have other plans for 18 and 19-year-olds, including expanding the opportunities at Return House, which is actually a great program in Barry. But from my perspective, I don't know what they mean by expanding the programming there. I'm waiting to see what that means. If expanding the programming there means turning it into a place that can accept, 18 and 19-year-olds who are in a state of clinical crisis, that might be, in fact, that they are doing the things they need to do to get us there. If expanding the offerings there just means expanding the bed space and not changing the sort of clinical offerings at Return House, then I would say they're not, because Return House is a great place for 18 and 19-year-olds who are in a place of stability and rebuilding. It's not a place for kids in crisis.
I guess I'm just having a hard time understanding how, if we have the resources for 18-year-old and that is successfully being implemented and 19-year-olds are not significantly different, how we don't have the resources for the 19-year-olds. Like, I'm really having a tough time. Like, how we can say on one hand, stuff with 18-year-olds is going great. And then on the other hand, be saying, oh, but that wouldn't work for 19-year-olds.
And I think that I'm stuck in a position of saying that I don't control DCF's budget or any of that. And so it's more of an appropriate question for DCF and for me. All I can say is what we experience on the ground and what we see in practice. And what we see in practice is that DCF is not ready or resourced to do this. And if April first rolled around and we had 19-year-olds in crisis in DCF custody needing services, DCF wouldn't have the services to provide them. And I don't want to see a 19-year-old in crisis being essentially unserviced. And I know that the services that are available to them now are not as good as the services that are anticipated in the raise the age legislation, but the services anticipated in the raise the age legislation aren't there.
So what I'm hearing is the Defender General's office, although not happy with the total outcome of H2, is in support of H2 presently. And that in your opinion, DCF or other agencies aren't where they need to be, but they're making strides. You can use the 2 steps forward, 1 step back, 1 step forward is still strides. And your concern is more about the well-being of your 19-year-old, more so than hitting a specific number. Come on.
Yes.
Thank you.
When we planned this, we planned for raise the age to happen in increments, and we did that for a reason, and that was to give everybody time to adapt and develop resources and develop programs and strategies that they need. And that got interrupted by the pandemic. And honestly, during the pandemic, that was 100% legitimate. There was nothing that could have been done about the delays that happened during the pandemic. The number of beds that DCF had available to it just plummeted because staffing plummeted. And every one of those programs is licensed on the basis of staff client ratios. So when staffing plummets, their ability to accept clients plummets. Staffing has not fully recovered in those programs. Staffing hasn't recovered in almost any industry in the state, and it definitely hasn't recovered in those programs, in part because, and I hate to say this, but while part of the outcome of the pandemic across the state was, as staffing recovered across the state, we saw actually a pretty dramatic increase in wages across the state. And that was true in a lot of industries. It wasn't true in the social services child welfare industry. We didn't see the same kind of raises that was happening. My daughter no longer works at the pizza place she used to work at. When she worked at the pizza place, she made more money than incoming ECF workers. She was an 18-year-old kid making pizzas. And ECF workers, we expect the supervising young children, who have been abused or neglected or who have committed delinquent acts and helping to rehabilitate them. And frankly, at the time, the pay was less than the pay of people who were making pizzas. And so there was not a lot of incentive. There was a lot of staffing problems. And I think we're still dealing with the tail end of that right now. And I'm hopeful that we're getting out of that, just like every other industry is getting out of that. But I think that the fact that the social services and child welfare industry is sort of trailing the rest of the world is a reflection of the resources that we put into it. It's been under-resourced since literally it began, in the 1800s, before the mid-1800s, we didn't really have child welfare cases at all. There was no system for the state to intervene in a family and say, we're going to take control of this child because either the child's being abused or neglected or the child's committing offenses, like that would be crimes if they were committed by adults. In the mid-1800s, we start with that system, and it has never been well resourced. It has always been the sort of four-step child of the criminal justice system, which gets all the resources. And that's kind of a messed up situation because honestly, every dollar you put into the juvenile justice system pays out in dividends in the criminal justice system. If you spend $2 in the juvenile justice system, you're saving $3 down the line in the criminal justice system. And that's been the case since 1800s, and yet we've never made the sort of shift in how we resource it. And so we see that not just in money, money is the obvious thing, but we see that in how young people are treated in the court system, period. It always upsets me when I see, for example, law offices, whether they're defense practices or whether they're criminal practices, who take whoever their most junior attorneys are and give them the juvenile doc. They treat it like that's the beginner's doc. When in my opinion, it's actually much more complicated and much more important and requires much more skills than the criminal docket does. And yet it's often used as sort of training. So I'm saying that all along, our juvenile justice system has been under-resourced from the beginning of the existence of the juvenile justice system to today. And if we ever resourced it well, we would really see a huge benefit because what has been proven incredibly clearly is the very direct connection between both the child welfare system and the juvenile delinquency system and the criminal justice system. In fact, part of just at this conference, I was at a panel where they were doing a discussion of what they call dual system youth who are involved in the child welfare system, meaning that they have been, the judge has determined that they were either abused or neglected by their parents at some point in their life, and use them in the juvenile delinquency system. Only about 2% of youth across the country have contact with the child welfare system, but 70% of youth in the juvenile delinquency system have had contact with the child welfare system. It is one system feeding into another, feeding into another. And that's the cycle that we want to break. That's the cycle that Raise the Age legislation is intended to. And that's what we hope in 2 years we are ready to go forward and break.
Marshall, I appreciate testimony, and since we do have a hard stop in town, we'll make sure Nikki has plenty of time to testify as well. So,
Yes.
If there is anything else though, did you have any further testimony or?
Only have these questions.
Oh.
Thank you.
Thank you.
Good morning. My name is Nikhil Goyal. I appreciate the opportunity to testify before your committee. I'm the founder of the Treat Youth Like Youth Coalition. I just want to take a moment to identify some of my credentials. I am a sociologist at the University of Vermont and former senior policy advisor on education and children for Senator Bernie Sanders on the U.S. Senate Committee on Budget and Committee on Health, Education, Labor, and Pensions. I developed preschool childcare, child tax credit, and tuition-free college legislation, as well as the Vermont Correctional Post-Secondary Education Initiative, which provides tuition-free community college education for incarcerated students and correctional staff in the Vermont state prisons. I taught sociology at UVM, New York University, and Wesleyan University. I'm the author of Live to See the Day, Coming of Age in American Poverty, which was the winner of the 2024 Media for a Just Society Book Award by Evident Change, formerly known as the National Council on Crime and Delinquency. I've written for the New York Times, Washington Post, Wall Street Journal, and other publications. My next book, An Examination of the American Juvenile Justice System, will be published by Harvard University Press in 2027. I hold a BA from Goddard College and an MPhil and PhD from the University of Cambridge. Let me begin with a brief story. A few years ago, an 18-year-old Vermont boy named Alex, a pseudonym, was struggling to cope with the death of a friend while working a shift at a gas station. All Alex wanted to do was return home and grieve. He didn't own a car, and nobody was able to pick him up, apart from a family friend who offered to give him a ride if he covered the gas expense. In a moment of desperation and lacking the necessary cash, he pumped gas into his friend's car, closed up the station, left without paying. His boss discovered his actions and called the police. Alex was arrested and charged with retail theft. In any other state in the country, Alex would have been prosecuted in adult criminal court. His hearings would have been open to the public. If convicted, he would have a criminal record, derailing his chances of future employment. But thanks to Vermont's Raise the Age law, Alex was sent to family court instead. Alex was asked about the circumstances surrounding his offense, and he was encouraged to make amends. He ultimately apologized for his behavior, paid back the gas station, and finally received the mental health treatment that he had been lacking. His misdemeanor was on the path to getting sealed. Stories such as Alex's show the positive impact of Raise the Age. And the law, as you know, has had a phased rollout since its initial passage in 2018, with 18-year-olds added to the juvenile system in July of 2020. Since then, the total number of juvenile delinquency cases have actually declined, even after this new age demographic was incorporated into family court. Alex and others like him have received individualized treatment and care, and Vermont has avoided the taxpayer expenses it would have occurred had it plunged more young people into the adult correctional system. But despite the success of the legislation, implementation of Raise the Age's second phase, which would bring 19-year-olds to family court, has been delayed 3 times. Now, Governor Scott, the same governor who signed the law in 2018, is calling for its repeal. And he is blaming a recent increase in overall crime in part on Raise the Age. And there's not a shred of evidence to back up these assertions. I would say that this is dangerous fear-mongering that evokes the super predator panic of the 1990s. More than a dozen Vermont and national civil rights and criminal justice reform organizations and advocates have joined our Treat Youth Like Youth Coalition, signing on to a letter urging the Vermont legislature to support the implementation of Raise the Age. Some of the members are leading national civil rights groups, such as the Children's Defense Fund, Juvenile Law Center, the NAACP, and Robert F. Kennedy Human Rights. I have an op-ed coming out with Kerry Kennedy, president of Robert F. Kennedy Human Rights, and daughter of Senator Robert F. Kennedy, who said, Raise the Age is a compassionate, effective way to invest in young people's future. When children and young adults are tried in the juvenile justice system instead of adult criminal court, they are far less likely to commit crimes in the future. Our coalition also includes the top juvenile justice officials who served at the Department of Justice under 3 presidents: John Rector under President Jimmy Carter, Shay Bilczek under President Bill Clinton, and Liz Ryan under President Joe Biden. And you will be hearing from Liz Ryan on Friday, tomorrow. Our demand is very simple. Remove the pause on Raise the Age from age 2 and keep the provision that raises the minimum age of juvenile court jurisdiction from 10 to 12. Children and young adults, as you've heard, are entangled in the juvenile system, are often living in poverty, housing insecurity, experience violence, abuse, mental illness, and other forms of trauma, and are disproportionately involved in the child welfare system. The last thing they need is criminalization. And prosecuting juveniles in adult court does not deter crime. According to a 2015 study, the 3-year recidivism rate for children tried in family court in Vermont was 25%, nearly half of the rate of those tried in adult court in Vermont. Family court isn't just more effective at deterring future crime, it's also developmentally appropriate. Drawing on neuroscientific and psychological research, examining the behavior and development of young people, the United States Supreme Court abolished the juvenile death penalty and mandatory life without parole sentences. And the court found in one of their opinions that children are different from adults due to their lack of maturity, vulnerability to poor influences, and unfixed character and personality. And thus they are less culpable and should be protected from these types of sentences. The same logic extends to young emerging adults whose brains are still developing into their mid-20s. For instance, Michigan abolished mandatory life without parole sentences for 18-year-olds. Massachusetts banned life without parole sentences for people under the age of 21. States around the country have begun to reform sentencing practices for emerging adults. Now, some have asked whether youthful offender statutes are sufficient. I support these statutes, but they are not sufficient for 19-year-olds who are accused of misdemeanors and less serious felonies. As one lawyer told me in Vermont, the young person, quote, has to hope he has a public offender who files a motion for youthful offender. There are overworked prosecutors who don't think of these things. Oh, look at your age. You could qualify for youthful offender. It's not automatic. Public defenders are spending 5 minutes with a client and not taking the time to say they have a choice to be treated in juvenile court, end quote. This lawyer explained the cumbersome process to me. You would file a motion for youthful offender, schedule a hearing in juvenile court, meet with a new lawyer who will represent you on YO, prep you for the motion, have a YO evaluation, then you go to the hearing and present your evidence. The judge will say yes or no. If he says yes, you're going to be in juvenile court. If you fail your consequences of juvenile court, you're back in adult court. A low-income or working-class young person who cannot take off work or has limited access to transportation to attend hearings, or is just simply unwilling to endure months and months of paperwork, meetings, hearings, and assessments will not benefit from youthful offender. They will simply accept whatever the adult criminal court gives them. And so by failing to raise the age for these 19-year-olds, we are putting them in harm's way. We are pushing them into an adult system of courts, jails, prisons, and punitive punishment, a system that lacks developmentally appropriate rehabilitative programs. When Marshall Paul talks about not letting 19-year-olds be set up to fail, that's exactly what we do when we put them in the adult system. As a sociologist and educator, I've spent an extensive amount of time in adult courts and prisons. And if you have not had experience in these institutions, you will underestimate how deeply traumatizing and violent these places are. So I want to be crystal clear. There is a human cost to pausing or repealing raise the age. People will be harmed. The Department for Children and Families have been instrumental in making raise the age a success. And the legislature should invest in additional family service workers for juveniles and expand restorative justice and other community-based programs. Most of the 19-year-old cases, as the implementation report indicates, will be dismissed, diverted, or result in a fine. So the idea that raise the age will somehow overwhelm the system is just blatantly false. 18 and 19-year-olds are very, very similar people in terms of their treatment. And so we cannot delay full implementation any longer. Each pause has failed to be accompanied by a plan of implementation. And as some may allude to, we cannot just simply wait for a new governor to be elected for raise the age to go into effect for 19-year-olds. Our international allies have much to teach us. Since 1953, Germany has been treating people under 21 who've committed nonviolent and violent offenses as juveniles with significantly lower recidivism rates than the United States. Moreover, Norway's age of criminal responsibility is 15, and it is rare for a juvenile to be incarcerated. Only in 2023, only 33 juveniles in Norway were sentenced to unconditional imprisonment, with most offenders receiving fines and community probation. The nation's restorative justice approach to juvenile offenders, very similar to that of Vermont, which involves a victim offender meeting and a youth action plan, is influenced by the United Nations Convention on the Rights of the Child. Governor Scott has argued that raise the age does not hold young people accountable. That's false. We believe in accountability. We believe in consequences for individuals who break the law. But we believe in accountability, that accountability should be dedicated to addressing why that individual committed the crime in the first place and helping them stop committing crime in the future. That's the difference. Despite accounting for 10% of the overall population, people ages 18 to 24 made up a third of arrests and a fifth of entries into adult prisons in the United States. Moreover, research has found that more than 2/3 of people in state prisons in the US had their first arrest before the age of 19. So raise the age is both fiscally responsible and anti-crime. Investments in juvenile justice pays dividends in the long term. Fewer arrests, fewer cases clogging courts, fewer people in adult jails and prisons, and safer communities. In a statement, Jay Blitzman, first justice of the Middlesex Division of the Massachusetts Juvenile Court, who's now retired, said, decades of developmental research demonstrates that even the most persistent and aggressive young persons will self-desist from serious misconduct with neurological and social maturity as they enter their 20s. Transitioning late teens into the more rehabilitative juvenile system will accelerate the process of maturational desistance. So all eyes are on Vermont. States all over the country will be observing how you respond to this moment. History will remember how you voted on H2 and whether you decide to amend it or not. And the choice is whether you vote to reduce crime and incarceration by supporting raise the age, or whether you vote to increase crime and throw more youth into jail and prison and waste taxpayer dollars by pausing or repealing raise the age. The choice is between following the science or denying the science. And the choice is between championing human rights or trampling on human rights. Vermont was the first state in the nation to abolish slavery. It was the first state to legalize same-sex civil unions. And it was the first state to raise the age of juvenile court jurisdiction to include young adults. As Vermont goes, so goes the nation. And we can show the United States that we can be smart on crime by treating youth like youth. We can rehabilitate, not criminalize, and stop the cycle of crime and incarceration all across our state. Thank you, and happy to answer any questions.
Thank you. Just one question. It might be for you, it might be for Marshall, and I understand if no one had the data on hand, but does anybody happen to know the numbers of 19-year-olds who are incarcerated for non-listed offenses?
I don't have that data, but I think it's a very, very small number who are in secure confinement.
Marshall, any idea?
I don't have the number, but I know that it's small. I could get it. I can request it from DOC and have it.
Oh.
As soon as you give it to me.
Okay.
I was gonna say by tomorrow, because they're usually pretty prompt, but during the legislative session, you never know.
Yeah.
How fast you're gonna get a response from people.
And you're referring to the non-May 14 events?
Yes.
Yeah.
Committee, any questions?
Just a quick one. I'm sorry. Thanks for being here.
Yeah.
What was the association wherever you, when you first started out, you belonged to? Or?
Oh, I'm a sociology professor at the University of Vermont.
No, your association, or you?
Oh, the Treat Youth Like Youth Coalition.
And is that a foundation? Is that yours, or what's the
Yeah,
membership?
it's an organization that was recently founded, and it includes a letter and an advocacy campaign on raising the age.
And what's your membership? What was this organization?
Well, as of now, we put out this letter, which has more than a dozen national Vermont organizations and advocates who have signed on board and provided testimony here and in other accounts in the media.
Thank you. And I guess it's a quick, would you find the statement made as, by Mr. This up here, Marshall, in reference to the public defenders only spending 5 minutes with their clients in reference to the possibility of going to offender status?
In fact, in order to get youthful offender, you have to spend a lot of time with your client. Basically, in order to get youthful offender status, just as it's not really the law, but just as a matter of practice, basically any attorney who does it with a risk and needs assessment and a psychological evaluation. And so, just the process of doing that alone is many, many hours, many, many dollars, and requires spending a lot of time with your client. And really getting into a lot of pretty deep detail with your client, because you're putting together a package to make an argument that your client has low risk to the public and a high chance of amenability to rehabilitation. And that's all really personal stuff. You can't do that just by saying, yeah, my client's young, give him youthful offender. No, nobody wins a youthful offender case that way. You win a youthful offender case when you come in with a report that is particular to your client, where somebody has actually used some actuarial data tools to say this person is a low risk to offend, and they are very amenable to treatment, and treatment programs are available in the state for them.
So you're spending more than 5 minutes.
Okay,
And then just to say that is, if you're a public defender who's already overworked, who's already overburdened with enormous caseload, the time that it takes to do that type of work, that is, as lawyers indicate to me, that is not the case that every child in Vermont is getting that same treatment.
but I'd also just like to be clear that Vermont public defenders, we don't have caseload caps like they have in some states, but we do track our caseload very carefully. We haven't exceeded APA caseload recommendations, except for one point in forgot what it was. We had a hiring freeze, and we had a juvenile lawyer from one office retire, and we couldn't hire somebody to replace them. And everybody's in that office is their juvenile caseload spiked because they had to take over the caseloads from that one guy. But other than that, we have always kept low caseloads in Vermont. That's part of the principles of how we operate our system, is to try to keep our caseloads quite reasonable. We don't actually believe that the caseload standards, the new caseload standards that have been set by the National Association for Public Defense, are actually much more interesting and much more relevant. The old caseload standards that were set by the National Advisory Council in the 70s, we think are so outdated that they really don't apply anymore. We really couldn't have attorneys having 200 cases like attorneys did back then. The practice law has just changed in a way that does not accommodate that.
I just want to make sure I'm clear. The point that you were making, Phil, with that sort of overworked, overstressed is not that youthful offender goes quickly. It's in fact that it doesn't, and people may not have access to youthful offender because it takes so long.
Sure, absolutely. And the other point is, if a child is going through that process, which can take many months, we have courts across the state that are clogged with cases. There's still folks trying to reduce the backlog. That child is not going to get any treatment. They're not going to get any support or rehabilitation during those many months. Whereas in the juvenile system, the chances are that it will go a lot quicker. And especially if there is a crisis that young person is going through, they will be more likely to receive that treatment from the onset. And then there's no guarantee, even if you go through youthful offender, that you will ultimately get those services in the family court.
Can I just comment on that? Because I want to back that up, because that's actually a really important point. Is in the juvenile court system, as lawyers, we treat our clients very differently than we do in the adult court system. And some of that has to do with the consequences and the way that you address things right from the beginning. So in the juvenile court system, as soon as I have a client who's charged with something and is my client, I start trying to get them services, because in the juvenile court system, that's super beneficial. I can walk into court and say, I've already got my client into these services, and that helps with the outcome of the case. Whereas in the criminal court system, there's essentially a principle of waiting until there's a finding of guilt to start doing any sort of intervention. And so that's one of the reasons why we do love the juvenile court system, is because we often walk in on day one of a merits hearing, actually having started programming and treating it already. And that doesn't happen in the criminal court system, except for the drug courts very often.
I appreciate that. That seems like one more reason why we should move forward with raise the age.
I agree.
Thank you for your testimony. We have to do a break and go to the floor now. So, yeah,
Thank you. Thanks.